Hello everyone. In this last presentation on general principles of criminal law, the elements of the offense of criminal conspiracy and criminal attempt are explained. Conspiracy means breathing together. In order to breathe together, the people have to put their heads together. Hence, in order to conspire, at least two men are necessary. Conspiracy is a tort as well as a crime. Conspiracy as a crime is defined under section 120A as an agreement between two or more persons to do or cause to be done anything illegal or to do a legal act by illegal means. Thus, essential elements of criminal conspiracy are two or more persons, agreement to do an illegal act or a legal act by illegal means. This offense was introduced for the first time as Chapter V-A in the Indian Penal Code by the Criminal Law Amendment Act 1913. Agreement is the essential ingredient of the offense. It is not necessary that all conspirators must know each and every detail of the conspiracy, so long as they are all participants in the object of conspiracy. It is not necessary that the devices and techniques to be adopted to achieve the common goal of conspiracy should be known to each and every conspirator. There must be unity of purpose, but there may be plurality of means which may even be unknown to one another among the co-conspirators. The only relevant factor is that the illegal acts done must be in furtherance of the object of conspiracy. Even where some of the steps are resorted to by one or more conspirators without the knowledge of the others, it will not affect the liability of others when they are associated with the object of conspiracy. Mere intention, however, is no agreement. There has to be announcement and acceptance of intention. When the agreement is arrived at, it would be sufficient to make the parties to the agreement liable for conspiracy. No overt act is required to be committed in furtherance of the agreement if the agreement is for the commission of an offense. If the agreement is for committing an illegal act which is not an offense, some overt act must be done in furtherance of the agreement. When all the accused except one are acquitted of the charge, the remaining one cannot be convicted unless the charge against him has been that he conspired to commit an offense not only with the acquitted co-accused but also with some other persons who have not been tried because they have been absconding or due to any other reason, and such a charge is proved. Section 120B provides punishment for the offense of criminal conspiracy in case where there is no express provision punishing the conspiracy of an offense. Now coming to criminal attempt. The commission of an offense consists of four stages: intention, preparation, attempt, and actual commission of crime. Formation of an evil intent in the mind of the offender is the first stage in the direction of commission of crime. Preparing or devising means or measures necessary to commit a crime is the preparation stage, that is, the second stage towards the commission of crime. The third stage in the series is the attempt to commit the offense. If the attempt to commit the offense is successful, he would be guilty of the commission of the offense, which is the fourth stage of crime. The code does not punish mere evil intention, which is not followed by an overt act because it is difficult to prove what is in the contemplation of an individual's mind. The act of preparation in general is also not punishable. Apart from its motive, it is generally considered as harmless. If intention and preparation were made punishable, it would be impossible to prove that the object of the accused is to commit an offense. For example, a man might purchase a gun for self-defense or for any purpose not necessarily for murder. But the state may consider the preparation of certain offenses itself dangerous and prohibit them through infliction of punishments. The Indian Penal Code punishes preparation to wage war against Government of India under section 122 preparation to commit depredation on a territory at peace with Government of India under Section 126 and preparation to commit dacoity under Section 399. Attempt takes the offender very close to the successful completion of the crime, and so it is punishable in law like the commission of an offense. An attempt is doing an act towards the commission of an offense, and if the attempt succeeds, the offense charged would have been committed. The problem that arises here is how to draw a dividing line between a preparation and an attempt. The code is silent on this point. It does not define an attempt, nor does it explain when an act would amount to an attempt. Though every case has to be judged on its facts and circumstances, some tests have been evolved by the courts to resolve this problem. These tests are proximity test, locus penitentiae test, equivocality test, impossibility test, and social danger test. Proximity test. Here, an act of attempt should be sufficiently proximate to the crime intended and should not be remote. Buying a gun and loading it with an intent to kill a person will only be preparation and not an attempt. Where the gun is fired but misses the target, the person will be liable for an attempt. Locus penitentiae, or time for repentance. Where there is time to voluntarily give up the idea of committing the crime, it is not an attempt. A buys a gun, loads it, and aims at B with an intent to kill him. Even now, he can decide not to kill and withdraw, and hence, so far, it does not amount to an attempt. Impossibility test. An act which is impossible to commit cannot be attempted and hence is not an offense. Example, A shoots at the shadow of B to kill him. A will not be liable for attempt because it is impossible to cause death by shooting at a shadow. Equivocality test. In order to amount to an attempt, the act must be such as to clearly and unequivocally indicate the intention to commit the offense. Buying a bottle of poison does not unequivocally point to the intention of causing anyone's death and hence is not an attempt. Social danger test. Seriousness of the crime attempted and the apprehension of social danger involved is taken into consideration to distinguish an attempt from preparation. Attempt to cause miscarriage is such an act. Section 511 of Indian Penal Code defines criminal attempt, according to which doing an act towards committing an offense with an intention to commit it and after making necessary preparation, though the act need not be the penultimate act towards the commission of the offense, yet must be in the course of committing that offense. For example, a man does not provide food to his wife and locks her in a room. The woman becomes weak and is almost on the verge of collapse. One day, the man leaves the house forgetting to lock the room. The woman escapes, reaches a hospital and collapses. She is admitted to the hospital and given necessary treatment. When the man was prosecuted, he pleaded that he could not be liable for attempt to murder as the omission of food was not sufficiently proximate to causing death to make him liable for attempt. The court held that the woman would not have survived had she not escaped, and the treatment which helped in her recovery was not because the man withdrew from his intention to cause her death by starvation. Hence, it was held that he was liable for attempt to murder, as the act according to section 511 need not be the penultimate act towards the commission of the offense. Indian Penal Code punishes criminal attempts in 4 ways. There are separate provisions punishing attempts of certain offenses, like section 307 punishes attempt to murder. There is a separate provision to punish attempt to commit suicide, though suicide is not an offense. There are certain provisions which punish both the offense as well as the attempt to commit the offence. Example, waging war and attempting to wage war against Government of India, punishable under Section 121. Other attempts are dealt with under Section 511 and are punishable with half the maximum term of imprisonment that can be awarded for the offence. Thus, in this set of 14 presentations, an attempt has been made to give an idea of the general principles of criminal law as contained in sections 1 to 120b and section 511 of the Indian Penal Code. Thank you.